of certain businesses. And then we'll talk about which types of intellectual property are most commonly used with those businesses. So first, a little bit about our clinic. There are 3 supervising attorneys involved. Kathleen Lombardi and I are the co-directors. And then Mary Miller is an adjunct professor. She is a partner at Reed & Riga, which is a law firm in Hartford. We supervise usually about 16 to 22 students each semester. The semester we have 18 students, and about 2/3 of them have a trademark background. They've taken the prerequisite courses, and then the other 1/3 have a patent background. We supervise their work. We end up co-signing documents or just signing the documents ourselves. So, so anything that goes into the USPTO or any opinion that goes out to a client, we have reviewed, but we do give the students a lot of latitude to do their initial drafts, and we have the students run the meetings with the clients. So it's a great learning experience for the students. And what's nice for the Connecticut entrepreneurs is that the services are pro bono. The clients pay the filing fees at the USPTO, but and then maybe some drafting fees for patent drawings. But other than that, there are no costs involved in working with the clinic. If you're interested in working with us, you can send an email to the email address that is on the slide down at the bottom, iplawclinic@uconn.edu, and we'll send you an application for clinic services. We generally start taking in new clients at the beginning of the semester, which means if you send your application in a little bit before that, like actually probably June for the fall, that gives us time to kind of organize and prioritize what we can take. We take almost all trademark applicants, and we probably take about 60 or 70% of the patent applicants. Some of the reasons that we cannot take everything if we don't have the proper technical background for the work. For example, I don't have a background in biology, DNA technologies, so we don't take those cases. And then with the computer implemented inventions, we get more cases than we can handle, so we don't necessarily take all of those. We really like simple mechanical devices because those provide a great learning opportunity for our students. We also take basic chemical inventions and engineering, kind of mechanical engineering cases. So that's kind of what we like to start the students out with. All right, so over the last 4 years, we've filed 99 patent applications. We've had 40 patents granted. We filed 102 trademark applications, and 92 of those have registered. So as you can see, the difficulty with patents results in a little bit lower grant rate than for trademarks. Some of these applications that we filed back in 2017 are still pending. Other ones may have been just abandoned. And a lot of these are still pending. I would say out of those filed over the last 4 years, particularly everything filed in 21 and probably even in 20 would still be in the pending stage right now. All right, I'd like to just go over the definitions of what is the difference between a patent, a trademark, a copyright, and what is trade secret protection. A patent gives the owner the right to decide how a new, useful, and non-obvious invention can be used by others. People think a patent is a right to do something, but it's actually a right to exclude others from doing that. And then in exchange for that, that temporary monopoly that the US government gives to the inventor needs to make technical information about their invention available to the public. So when you file a patent application, you have to describe the invention in enough detail that somebody else could pick up the document and they could make and use the invention. With patents, it's important to file your application as soon as possible. In the United States, we have a grace period that allows you to wait until your application or your technology has been out in the public for a year. But if you want a foreign file, you should really file your US patent application before you've disclosed your invention to anybody. So we prefer to have clients come to our clinic before they've had any type of public disclosure of their invention. In a little while, we're going to talk about provisional patent applications and how you can kind of use those to help avoid a public disclosure before filing. But then in contrast, now looking at trademarks, the purpose of trademarks is different and the timeline for filing trademarks is different than for patents. The purpose of a trademark is to give the consumer or the public a sign or a symbol that will help them distinguish your goods from somebody else's goods. The trademark applications can be filed before the trademark is used, but the USPTO won't grant the applications until the mark is actually being used in interstate commerce. So unlike patents where we want the clients to come to us very early, with trademarks, it's fine to come early, but we probably will recommend that you wait and not do your filing too early. Also with trademarks, as we're going to be talking about in a little bit, you can indicate that something is being used as a trademark even before you file. So, so there's a lot more leeway in sort of what you're doing with your business with regard to any trademarks versus patents. Then copyrights, we're not going to talk a lot about those today, but anyway, that term is used to describe the rights that creators have over their literary and artistic works. I hear a lot of background noise. I wonder if there's somebody who could. I don't know if, okay, now it's good. So with copyright, you can choose to register with the US Copyright Office, or you can simply just put your own copyright notice on your pages, which is a common thing, for example, for anybody who has like an online business. The fourth type of IP we're going to be talking about today is trade secrets. That can be business information or technical information that provides a competitive edge to the owner and the user of the information. Oftentimes it would be like a manufacturing process at a plant or a customer list for any type of business. So at this point, I'd like to stop and see if there are any questions about the basic differences between patents, trademarks, copyrights, and trade secrets. We're then going to discuss each of these in a little bit more detail. Okay, so moving on, since I focus on patents, I figured I'd start by talking about them. There are three different types: utility, design, and plant. Utility patents are what people usually think of when they say I've patented something. And for patentability, the invention has to be useful, and then it has to be both novel and non-obvious. The difference between what's meant by novelty and non-obviousness is novelty simply means new. If the exact device isn't already out there, either as a physical product or described somewhere in the literature, and this could be literature anywhere in the entire world in any language, if it's not out there, then it would be novel. But in addition to that, in order to get a patent, you have to establish that the invention is non-obvious. And the standard for that is whether based on what's already out there, whether the invention is obvious or not to somebody of ordinary skill in the art. And the question is, what does that mean? What is ordinary skill in the art? Well, the basic way to look at that is if a technician were given the prior art, could they get to the invention? If so, then it probably is obvious. On the other hand, if it would take an engineer to get from the prior art to whatever your invention is, then that would probably make it non-obvious. In other words, some engineering skill is required, and that's considered beyond what somebody of ordinary skill in the art would do. With design patents, they are quite narrow. And I don't know if many of you are aware of the litigation over the iPhone. It was the Samsung Apple litigation, but the picture that I've shown in this slide is the patent that Apple got, and they successfully enforced it. It took many, many years, but they did successfully enforce it against Samsung and got a huge settlement. So when you look at a design patent application drawing or design patent drawing, you'll often see a combination of solid lines and broken lines. For example, in this Fig 1 that I've shown, the home button is shown with a solid line shaped like a circle, and the screen outline is shown with a broken line shaped as a rectangle. The curved edges of the phone are shown with a solid line. So what Apple was protecting with this particular embodiment, they actually had several different embodiments in one patent. They were protecting the shape of a round home button and the curved edges of a rectangular phone. And that's all they were protecting. And I think it's pretty impressive that they were able to succeed in getting that patent and enforcing it. To lots of people, these look like very basic functional features, but they were able to successfully argue that a home button doesn't have to be round. It could be oblong or triangular, and the edges could have been a different shape. They could have been, for example, sharp edges. So the takeaway from this drawing is anytime you have a useful product, you might want to consider whether it's worth filing a design application. They're not very expensive to file, and they'll at least prevent knockoffs if you can get the patent granted. The third type of patent are plant patents, and they're directed to plants that are not produced from seed. I've actually never filed one. I know that the University of Connecticut out in stores, in connection with their agricultural program, they have gotten some plant patents, but I really can't tell you any more about them other than what I've already told you. Any questions at this point about the three different types of patents? Okay, one more thing that I would like to add is the utility patents are good for 20 years from filing. Sometimes you can get a little extra extension because of like FDA approval or a slow examiner or something like that. But it's usually about 20 years from filing. And design patents are good for 15 years from filing. 15 years from grant. One of the differences between utility and design is that utility patents are published 18 months after they're filed, unless you specifically request that they're not. But most, I would say probably 95, 98% of utility applications are published 18 months after their earliest priority date. On the other hand, design patents remain confidential at the USPTO until they're granted. Okay, you've probably heard the term provisional patent application. You notice I didn't put that on the last slide because a provisional patent application itself does not become a patent. What you have to do if you filed a provisional, then you have to file a regular or non-provisional patent application within a year. And then that non-provisional patent application can mature into a patent. The United States and Portugal are the only countries I'm aware of that have a provisional patent application filing system. The advantages of provisionals are they're particularly good for small inventors and startups because you can get something filed before you do like a pitch or before you want to or before you need to invest a lot of money in the idea. And they're good for professors who want to give a presentation at a seminar. For example, a scientist who wants to share their discovery, they can file their article or presentation materials as a, they can file their presentation materials as a provisional patent application. They're also very inexpensive. The cost for a provisional ranges from $75 for a microentity up to, I think it's now $280 for a large company. They do expire after 1 year. So once again, you can't just keep it going and you can't file like 3 in a row and claim back for 3 years. But they can be in any format. And that's what's nice. You can, if you don't want to hire an attorney and our IP clinic can't help you in the timeline that you need, you can file anything you want. And it basically covers substantively whatever's in the disclosure. They never get published by the USPTO unless later there's a non-provisional that's filed based on that provisional. And then eventually it would be accessible by the public. But if you don't ever follow up or if you don't claim priority, then it would never get seen by anybody else. You don't have to include patent claims in there, and the patent claims are the part that you generally want to have an attorney help with. And they allow you to describe your product and or process as patent pending. So if, for example, you have a pitch coming up and you want to be able to say patent pending, you can get that provisional filed and then you'll be able to say patent pending. Now, one caveat is if the novelty of your invention is the design, you know, thinking back to that Apple design patent, you can't use a provisional. You just have to go straight in and file your design application. Does anybody have any questions about provisional patent applications?
Yeah, I think that somebody asks, is there funding available for the inventor to get a non-provisional patent? But I think that you're not funding, you're basically subsidizing the costs of the attorney, but the rest of it, the filing fees, those things I think the inventor is basically responsible for.
That is true. Yes, through the IP clinic, for example, we provide pro bono services, and then what we do to pay the fees is we ask for our clients' credit card information. We will then pay the USPTO fees directly. There's no surcharge or anything. And so our clients are responsible for those fees. And for a utility patent application, if somebody is a micro entity, the current rate is $455 for filing a non-provisional and $75 for filing a provisional. The rates for small entities are about double that, and the rate for large entities is about 4 times that amount. So actually, unlike most other countries, there's very reasonable fee schedule for independent inventors and small companies. A lot of countries don't have that. They charge everybody the same thing, or they may only have a small entity fee, but they wouldn't have a micro entity fee the way we do.
There may be some funding available if people apply for a CT Next grant. I know that Sherry Denty, who was running that program, was offering her services. I don't know if you can actually budget for the filing fees, however. That's something that I haven't really explored.
Thank you. So then I'm going to give you an example of the timeline for getting a patent. And while I've titled this slide, Patent Matter Handled by the IP Clinic, from the sort of point of actually filing at the USPTO to the grant of the patent, it would be pretty much the same if you were working with a law firm. The difference is if you're working with a clinic, because we're a learning lab, things move a little bit more slowly from the point of client intake to the point of actually filing the patent application. So what we do first is we review a new application and we conduct a conflicts check to make sure that we don't have any similar clients either in the clinic or with either of the two firms where Attorney Miller and I work. And if we look like everything is clear there and we've run it by all the students, because actually some of our students are concurrently working for law firms, then a student and their supervising attorney will hold an intake meeting. Right now, we're doing those meetings by WebEx. We're still hoping maybe in the fall we'll be back live. We'll just have to see how everything is going. If it looks like there's something that we can do for you as a client, then we'll send you a letter of engagement for pro bono services. And then once that's signed and returned to us, then our student will prepare a patentability search and write up a search report. That's a really nice service. Generally, if you're hiring a private attorney, you won't want to pay to have a patentability search and a written search report done. For us, it's a great learning tool for our students, and it helps them write better claims. But I would say if you're working with a law firm, you may want to do your own searching and send it to the attorney that you're working with. Sometimes you will want an attorney to do a search, but typically in a private firm like where I work, if I have a client who wants to search, I'll farm it out to a professional patent searcher because A, they're faster, and B, their hourly rate is a little bit lower than an attorney rate. And then generally what a law firm would do would probably just send the search results to the client and wouldn't spend the time writing up a report. Instead, the attorney would use those search results to figure out how to write the claims. So let's assume that the invention looks to be patentable. The next step is to file a provisional or a non-provisional patent application. I would actually make the same recommendations whether it was a clinic client or a law firm client, and that is start with a provisional if there's no prototype. Otherwise, move straight on to the non-provisional if you do have a prototype, or if it's something similar to what you've done before and you have a prototype for an earlier version. The reason that we often recommend a provisional if there is no prototype yet is things are likely to change, as you all know, going from the sort of initial conception stage to the reduction to practice. Once you file a non-provisional patent application, you can't make changes unless you refile, and then you have to pay a brand new filing fee, you get a new filing date and all of that. So by starting with a provisional, it gives you a year to build the prototype, make changes, and then just go in with a complete application, the non-provisional, after you have your prototype. So that's just a general recommendation. If somebody really wants to go straight to a non-provisional, we are happy to do that. So yeah, so months 6 to 17, that would be going through the converting the provisional to the non-provisional. We'd have to make sure that we filed within a year, and then we'd file the non-provisional application. And then there's a waiting game where we just sit and wait for the patent office to pick up the case. Depending on the technology, it may be a short time or it may be a long time. Right now, the patent office is short on examiners who have electrical engineering and computer science backgrounds. So those cases seem to take a particularly long time. Otherwise, it really depends on the subject area and how many examiners they have. And there aren't really other patterns that I've seen recently. So once an examiner picks up the case, they will normally issue a rejection the first time around. Once in a while, they'll go straight to an allowance. But if they issue a rejection, it's not necessarily a bad thing. It's just more typical. It's more of a typical procedure. And then what the attorney and the student will do is they'll narrow the scope of the claims a little bit, file a document back with the USPTO, and then hope the examiner accepts it at sort of that second time around. Oftentimes, unfortunately, the examiner doesn't accept it the second time, and then you have to go back and forth several more times before you can get your patent application through. Typically, it takes this whole process from filing, whatever's the earliest filing date, whether it's a provisional or non-provisional, typically takes 2 to 4 years. Sometimes it takes longer, and once in a while we've gotten something very quickly, like in about a year. The UConn Law School program is part of a USPTO sponsored law school certification program. So we are permitted to fast track 2 applications every year. And by fast track, what I mean is we file a request for quick consideration. And there are advantages and disadvantages in doing that, however. The advantage is if you want to get narrow claims, we can get something through quickly. The disadvantage is that usually if you want broad claims, you end up with a very early final rejection, and then you have to pay a continued prosecution fee. So I would say that we only file probably 1 of those per year. The nice thing about being part of the law school certification program, however, is it doesn't cost anything to file that. And the reason the Patent Office lets us do that is it gives a student an opportunity to both file a case and work on the patent prosecution for the case. So it's of benefit to the students. Otherwise, if you're filing through a private attorney and you want to fast track, it's quite expensive. I don't know the current cost, but I think it's over $1,000. Might even be a couple $1,000s. So does anybody have questions about the timeline for patents? Okay, so we're going to move on and talk a little bit about trademarks. Trademarks, as I'd said before, their purpose is to designate the source and origin of goods, and the beneficiary of that is the public. You don't have to register a trademark. In fact, if you just put the TM, as you'll see in the upper right-hand corner of this slide, you just put TM by the name that you're using or the logo that you're using as your trademark, that starts everybody being on notice that you have common law rights in that trademark. One of the challenges with trademarks is you have to make sure that you use them properly, and because you don't want to lose the trademark rights, for example, by your mark becoming generic. So words like aspirin, thermos, and escalator used to be trademarks, but what happened is the owners didn't police them. People started using those words as a generic term, and so they ended up losing their trademark protection. Some years ago, the company Xerox noticed that people were starting to use the word Xerox as a verb. Oh, would you Xerox this document for me? So they started an ad campaign in which they said that a Xerox is basically a trademark. It's not a generic term or a noun. So when you use a trademark, you want to think of it as kind of like an adjective, like Coca-Cola beverage, with Coca-Cola being the adjective describing the source of the beverage. When clients come to us, they may have a website and they may want to use their business name as a trademark. That's great. We can actually coach you on how to properly use your trademark as a trademark, even if it's also a business name. So it's not complicated, but you have to sort of learn and figure it out and get some good advice before you get it right on your website or your specimen. Now, why should you bother to register a trademark? I just told you, you can have protection by just putting the TM on there. Well, there are several different reasons that you want to register. And one of them is if you decide to enforce your trademark, then you can, accuse somebody else of federal trademark infringement. Another reason that it's useful to register is if there are any problems, it's nice to find that out early when you're just starting your business. And so if you file an application for registration and the trademark examining attorney comes back with something that's very similar to your mark with similar goods, then you'll know that, oh, maybe you should change your mark. And so that's another advantage of registering. You'll find out who else is out there. Now, in trademarks, what matters is whether other people are using a similar mark for similar goods and services. If somebody's using the mark for something that's completely different, unless it's become a very famous mark, people probably won't associate the two products as coming from the same source. So when our students do searches, they, and once again, I'm assuming that these are for like startups and new businesses. We will search the trademark office database because that's what the trademark examining attorneys will search. And then we also search on Google, which is something, of course, you can do yourself, to see if there are unregistered users of the mark out there. It's trying to decide whether something is close enough to be a problem or not is quite an imprecise decision-making process, because a lot of times there are things that are similar. So sometimes what we'll do is we'll tell a client, yeah, we might be able to get this through, but if you want to tweak it a little bit, make a few little changes, you might be able to have greater distinction over somebody else's mark. So those are some of the services that we provide to our trademark clients. So looking at the timeline for a trademark matter that the clinic is handling. Once again, step one is the same. We review the application, we conduct a conflicts check. If everything works out there, then a student will reach out to schedule an intake meeting, and then if appropriate, we'll prepare a letter of engagement. The next step for trademarks is to do one of these registrability searches, which I've just been talking about. A typical search like this would probably be 15 pages long. The student would probably have 10 to 20 similar marks that they found. The search might be for a word or it might be for a logo. We generally do those as two separate searches, even if the word is encompassed in the logo. A lot of times clients want to start by filing only one registration, and if they have both a logo and a word, we recommend that they start with the word mark because that's broader, since that covers that word used in any context, whether it's in a logo or just somewhere else. So then if this search report is favorable and the client is ready to file, then the student would prepare an application where they would describe the goods and services of the client in a very particular way, which, you know, is strategically designed to get through the trademark office. Filing fees are $250 to $350 per class. Once again, we use client credit cards, and sometimes people want to file before they're using their mark in interstate commerce, just because you get the benefit of that date if there are other people who then file after you. The disadvantage of filing too early is you may end up, if your mark goes through quickly, you may have to pay some extension fees until you can actually prove that your mark is being used in interstate commerce. So anyway, whether you're working with us or with a law firm, that's something that you want to think about. Do you want to file early and risk paying extension fees, or do you want to wait and take the gamble that somebody else is going to try to register a very similar mark for very similar goods? But as I said before, well, I can explain this a little bit more. When you are using the goods in interstate commerce, what you have to file at the trademark office is a specimen, or a PDF of a specimen. So what a specimen is a photo usually of a product that has a tag on it, which uses the trademark, or it's, you know, some other way showing how the mark is being used in interstate commerce and that it is being used in the trademark sense. After the application is filed, if it's submitted through the IP clinic, it's automatically processed quite quickly because there's a different set of trademark examining attorneys that handle the IP clinic cases from all over the country. I think there are like maybe 35 law school clinics. And so you do get that advantage of expedited consideration if you go through the law school program. That's another reason, though, that you would want to make sure you don't file too early if you're not really ready to start selling product. Selling one product to one friend or relative out in California isn't enough to show interstate commerce. It has to be like real sales, and we always look for multiple sales. So, and once again, just doing business within the state of Connecticut isn't enough to show interstate commerce. So because trademark protection is federal, that's why they have this interstate commerce requirement. Now, sometimes people ask, well, okay, I have a store that's only in Connecticut. I'm not going to expand beyond Connecticut. What do I do? Then what we can do is we can file a state trademark registration. Those are, you know, fairly easy to do, fairly easy to get. And it's some level of protection for a business that doesn't plan to go beyond the borders of the state. Typically, federal trademark registrations come through 8 to 12 months after their filing date, much, much better than the patent timeline. So anyway, does anybody have questions about trademarks and the trademark filing process? Okay.
I guess I have a basic question. So
Sure.
Sun Microsystems has a trademark on a term called Java, which is making a reference to the Java programming language. But Netscape came up with a language that they called JavaScript. Now, did that dilute their trademark by confusing the customers? Because a lot of people stare at the JavaScript books and say, which one should I get, Java or JavaScript? And I've seen them do this in bookstores. It seems like someone dropped the ball on trademarks.
These are these both from the same entity?
No, completely different entities.
Yeah, I'm surprised. I agree with you. I think that would be quite confusing for the consumer. So, you know, whoever came up with the first mark probably could have gone after the other company for causing consumer confusion. Maybe they had some arrangement. You can sometimes, for example, you can enter into a consent agreement with another party about how you can coexist, but it's probably more common that people just don't really pay attention to what others are doing, and that it is just a matter of oversight. So that may have been the case there, but that isn't something that I actually heard about before. So that is quite interesting, because
And we had a question on the chat here, and someone asked if you could say a few words on how to use provisional patents for professors before a pitch or a conference.
Sure, yeah. So typically if somebody came to us and said, yeah, I'm giving a presentation next week at a scientific conference and I have a slide deck, we would say, okay, if you want to send us a slide deck and any like draft articles that might also be associated with that presentation, we'll file those in a provisional patent application. What we might do is we might include a couple of broad patent claims that would, essentially cover whatever is the essence of what is new and non-obvious about that invention. So the cost for that is, it's $75 for a micro entity. I think that's $150 for a small entity. Or also if it's being filed through a university, they get reduced filing fees that are similar to the small entity fees. And actually in some cases, universities can even get micro entity fees. So we generally just file the actual documents, the actual materials that will be disclosed. That's kind of the quick way to do it. Otherwise, sometimes somebody will, if they have a lot of time, they'll get somebody to prepare something that looks more like a regular patent application. A regular patent application, it'll have like a background section, a summary section, lots of drawings with lots of reference numerals on it. But that's not really necessary for getting the substance protected. Those are really more formal requirements. So it depends a lot on what the, sort of what the technology is and how complicated it is. But our general advice is to err on the side of over inclusion and put more materials in the provisional than you think you're going to need. And you don't need to worry so much about organization. You just want to get it all in there, because then when you file your non-provisional, anything that was disclosed as part of the provisional has the effective filing date of the provisional. And that way, if say you go to a conference and you present your innovation and then somebody goes back to their lab and they start working on that project and they sort of take it to the next level, you have already your filing date before whatever they're doing. And so back in 2013, I think it was, we became a first to file country like the rest of the world was. So whoever files first gets the patent rights, rather than the old system in the United States was whoever invented first. But we are now a first to file country. And so does that answer the question about using the provisionals?
Sounds like it does to me. Thanks.
Okay. All right, so I'll talk a little bit about copyrights. We do very little work. We probably have, like right now we're working with about 80 trademark clients and about 50 patent clients and maybe 2 copyright clients. Generally, the people who come to us for copyright help have like hard copy books that they're publishing, or and sometimes they're illustrated books, say an illustrated children's book or something like that. We can help give advice about how to submit things. We will actually submit things to the Copyright Office. The filing fees, $40 to $65 per application. Registration is pretty straightforward. You submit it and it's usually accepted, and then you get the registration. If you have a work that you think somebody might take, it is a good idea to register the copyright, because if you want to sue somebody for copyright infringement, in order to collect damages, you want to have that copyright registered. The more common types of things that we do in the clinic are just giving clients general advice about copyright notices. Because people change their website so frequently, they don't usually register a copyright for a website, but it is a good idea to put a copyright notice on the bottom of each page of your website. I'm going to talk about that a little bit more in a few minutes. All right, trade secrets. What should you keep as a trade secret, and how should you decide whether to go the trade secret route or the patent route? Well, some examples of trade secrets: customer lists, processes of making products, processes of using products. Sometimes chemical formulations can be trade secrets. Sometimes they can be reverse engineered. So it sort of depends on the subtleties of those formulations. If something can be reverse engineered, it's impossible to keep it as a trade secret, unless it's something that could only be reverse engineered by employees who have signed NDAs, and therefore that would be illegal. But if it's a product that you're selling and somebody can take it apart and see how it works, then its construction is not a trade secret. Sometimes the materials a product is made out of, that could be a trade secret, because, you know, analysis can only go so far. Coca-Cola still claims that their recipe is a trade secret. Obviously, people have done lots of chemical analysis of that and gotten pretty close, but arguably that Coca-Cola formulation is still a trade secret. The key to maintaining trade secrecy is simply to keep the idea a secret. One of the important things is, particularly if it's part of like a business, is that the only people who know the secret are those who have a need to know. And usually you want to kind of document that so that if an employee ends up leaving and either accidentally or intentionally disclosing the secret, that you have some recourse against that employee. That's one of the more common ways that trade secrets lose their secret status, is through a former employee or even a current employee. It's a good idea to get an NDA signed. First of all, if you have a startup company and you're starting to hire employees, if it's a tech company, and even if it's not a tech company, you probably want to get some non-disclosure agreements signed so that your employees understand that they can't take the company's secrets out anywhere else. Customer lists, for example, can be really, really valuable for competitors. So you want to make sure that your employees know that they can't, if they leave the company, they can't take the customer list over to a competitor and start using it. There's one interesting strategy that I wanted to just let you know about regarding the intersection between trade secret law and patent law. In the United States, if you're only filing a US patent application and you're not doing any foreign filing, there's a box you can check on the document you submit that asks that the application not get published until it grants. We've done that for a couple of our clients. There are sometimes reasons that you would want to do that, and then on the other hand, there are reasons you would not want to do that. But if you're not sure whether to keep something as a trade secret or to try to get a patent on it, you can try to get the patent as long as you're only filing in the US. And then if you get the patent, then you can let it grant and give up the trade secret status. If you never get the patent, you can maintain the secrecy of that by just letting the pending application go abandoned if it looks like it isn't going through. You can't do that in most other countries. In fact, I don't know if there are any other countries that you can do that in. And the history behind that is because we used to have a system in which patents were not published until they were granted. So when the law changed, in order to protect independent inventors and other people who might want to keep something a secret so that somebody else doesn't come in and start, using it or improving it, they wrote into our, America Invents Act that you could still keep applications secret. There are reasons that you might not want to do that. And that's the thing, most of our clients don't. And that is because one of the advantages of having your application published 18 months after you file is it puts the world on notice as to what you're doing, and it actually makes other people stay away. So if you kept your invention a secret and other people didn't know what you were doing, they might unknowingly start doing the same thing. While if it's out there that you're working on this particular technology, other people may go in different directions because they don't want to do exactly what you're doing and end up with a legal problem. Any questions about trade secrets?
Yeah, I've got a question. We
Sure.
ran into a lot of issues with industry trying to use our students to do development and have them sign non-disclosure agreements. But some of those students are international students. How do you enforce a non-disclosure agreement when a student graduates and goes back to their country?
It would be hard to do. So I think that the company who is signing, having the student sign the NDA, that's just a risk that they're taking. So that's, yeah, I would say that's a good question. And you can only, what we always tell our clients is just do business with individuals you trust. Because even if you have an NDA in place, the bottom line is you want to make sure that whoever you're working with understands the obligations of secrecy and keeps the idea a secret. So, okay, so we're going to now look at 6 different types of businesses. And I think I'm going to go through this fairly quickly just because I want to leave some time for questions. And so what we're going to look at is for each of these businesses, whether it's likely or unlikely that they'd be looking at patent, trademark, copyright, and trade secret protection. So first one, restaurant or a brick and mortar retail store. Very rarely do these types of businesses get patents unless they have some unique business model. They're probably all about getting trademarks because that's the way they're attracting and keeping their customers. And we would generally recommend that they register those trademarks. Copyrights, it's likely that they have inherent copyright protection in their menus and signs. Copyright protection starts as soon as you create a work. So you can always, as soon as you create it, you can put the copyright notice on it. Restaurants and retail stores often won't bother to file federal applications for registration because they change their menus and signs all the time. And so there's really no reason, unless there's something that they're using long-term, then they might want to register it. And then with trade secrets, as you'll see with these slides, pretty much every business is going to have some trade secrets that they keep. So for a restaurant, it might be recipes. For everybody, it might be customer mailing lists. Second one is an online retailer. Obviously, if you're Amazon, you're going to have a lot of patents, but most small startup online retailers probably won't have a lot of patents for their business processes. Those are some of the hardest patents to get. Business processes and biotechnology are the 2 hardest to get, just because the Patent Office considers a lot of those innovations to be intangible. Online retailers, once again, probably are using trademarks on their website, and federal registration is recommended because their business is probably national and perhaps even international. With copyrights, we generally recommend that an online retailer put the copyright notice at the bottom of each web page. So basically you'd put either the word copyright or the C with a circle, and then you put the year, and then you put the business name. Once again, usually online retailers don't bother with federal registration unless they're, if they've grown to be large and they're not changing their website a lot, or they're worried that somebody's going to knock off their website and steal their customers. But I would say if you're a startup, you probably wouldn't bother with registration because you're going to continually change your website. The trade secrets, you might have website software and customer mailing lists as some things that you just want to keep secret. And you just want to make sure that your employees know those are secret. All right, the third example is a lab that does pharmaceutical research. Patents are going to be very important to them because you can potentially get protection for the active ingredient, the composition that includes that ingredient, combination of the ingredient and whatever kind of carrier you have, a method of making the product, and a method of using the product. Now, this is an oversimplification because there are certain things that you can't get patents on. Medical diagnostics as a category is something that you generally cannot get patents on, but there are strategies for writing claims to basically protect portions of an invention, even if you can't protect the whole thing. Trademarks are widely used in the pharmaceutical industry. Once again, registration is recommended. With copyrights, it's useful to include copyright notices on marketing materials. Whether or not those get registered probably depends on how often they change. And with trade secrets, I put the medical diagnostics down there because that might be something that you can at least keep as a trade secret for a while, although once the product is sold, then you have to tell people what it's for. Products of nature you can never patent, and marginal improvements over the prior art you might not be able to patent. So you might keep that as a trade secret at least for a while until the product has gotten through the FDA and you're ready to release it. Okay, developer of mobile phone apps. We get a lot of young people coming up with interesting innovations in this area. Everybody would like to patent their mobile phone app, but given the timeline that I showed you of like 2 to 4 years, you probably will have changed your app before you even get the application filed, the patent application filed. So we generally don't recommend going through the patent process unless there's something very unique that you think you would end up using for a long time. Now, design patents or logo type trademark registrations can be used for the icon or the graphical user interface that is used to access the app. If you think you're going to be using that once again for a long time, design patents go through the patent office a lot faster than utilities. And then with trademarks, they're useful for the word of marks and the logos, and we do recommend registration. Copyright protection is available kind of like for a website. You could put it on screen displays, but if it's a mobile phone, it's going to be so small, it's probably not worth doing. Probably want to use your screen for other things. And it's unlikely that people file federal registrations for copyright if it's for an app, but obviously they could. Trade secrets might be the software and the customer mailing lists, kind of like the other examples we've looked at. Okay, an accounting firm, what might they try to protect? Well, probably they won't be filing a lot of patent applications unless they have some unique business model. For example, banks will sometimes file patent applications, accounting firms less likely to. Trademarks are useful for, once again, identifying your particular firm and letting the consumer know that, you have a certain level of quality. Copyright notices would be used on websites and forms. You could register it, but I think a lot of people probably don't bother. And with trade secrets, you probably have some interesting internal business processes and customer mailing lists that you'd want to try to keep secret. So once again, you would just want to make sure that only a limited number of people really had access to this information.
I am sorry to interrupt. I had a question here on the chat, and it was on the trade secrets. Apparently, there's some sort of mobile app, and they're wondering if it's violating a trade secret if they disclose what software is being used to do the development. I assume they mean whether they're using a specific IDE or a specific Java program or something like this. I can't imagine why that would be a trade secret.
Yeah, I don't think there's any problem with disclosing that, because given that that's a publicly available product, what makes the secret valuable is what you're doing with that product. So I don't think it's a problem to say what kind of if you're using Java or whatever you're using. That's a good question. So then athletic shoe designers, patents would probably be something that they would pursue. Utility patent protection for anything that's unique about the shoes from a functional standpoint. Maybe they're comfortable, maybe they're durable, maybe they look new for 2 years. And then design patent protection can be useful for the overall look of the shoe or for even a portion of the shoe. Remember how earlier we were talking about broken lines and solid lines in a design patent application? I saw once a patent for, I think it was like a sort of a dockside shoe, and they only had one little triangle on the back of the shoe shown in solid lines, and the rest of the shoe was shown in broken lines. So essentially what you can do with design patent applications in that context is it's sort of more like a trademark, that you have some particular shape for a certain part of the product or maybe the whole product, and you claim design patent protection for that. Trademarks, once again, that's a big important type of protection for an athletic shoe designer. Copyrights, you might once again put notices on website pages, probably wouldn't bother to register. And then trade secrets, it would really be similar to the other businesses, maybe some internal business processes, customer mailing lists. Maybe you have some unique manufacturing methods, if you haven't tried to patent them, that you would want to keep a secret. All right, well, that's what I have for today. So what other questions do you all have?
Could you reprise the differences between the trade secrets and the patents, when they're appropriate, and the cost and the application?
Okay, I'm just going to repeat the question to make sure I had it right. When to use trade secrets versus patents and the costs involved?
And the application, yes.
And the application.
And the filing methodology for trade secrets.
Okay, with trade secrets, you don't file anything. You simply keep it a secret. So nobody knows that you have a trade secret. There's no registration system, no filing system. You just simply keep it a secret. So the only costs are the efforts that you need to make to keep it secret. With patents, on the other hand, you have the filing costs. You can either use the clinic, or if you're hiring an attorney, you have the patent application filing costs. And in addition to, and the government filing fees. In addition to the costs for filing the application, if you're working with a law firm, you'll have what are called prosecution costs. And prosecution is the term used to describe the back and forth filing of documents between the attorney and the USPTO. And as I said before, that can go on for a number of years. Typically, if you're working with a law firm, typically to get the application on file, it would probably cost between $5,000 and $15,000, depending on how complicated the technology is. And then the period of patent prosecution is probably going to be another $2,000 to $8,000. And then the grant fees are very low. It's, well, for a micro entity, I think it's $300. So a small entity would be $600, a large entity would be $1,200. So the fees involved in patents are more about attorney's fees than they are about government filing fees. Does that answer the question?
It does. Just a little bit more clarity on the, exactly what is the prosecution?
The prosecution is when the attorney sends documents to the patent office and then the patent office responds. And so when the attorney sends documents, they will have described or quote claimed the invention with a certain set of words. The attorney generally starts with a very broad description of the device. Let's just say it's a chair. And the attorney describes the chair as having a seat and at least 3 legs. And then the patent office comes back and says, well, here's this stool. It has a seat and at least 3 legs. So I'm not going to give you that broad scope of protection for a chair. So then the attorney writes back and says, okay, well, because really what ours has a back and it has armrests, it has 4 legs. So then the attorney would write back to the patent offices and change the claim and narrow it. So it only covers things that have 4 or more legs and they have a back and they have armrests. Hopefully then at that point, obviously this is not a real example, then the examiner would say, okay, you've gotten over the prior art, I will allow your application. And then hopefully at that point you get a notice of allowance. That's of course, assuming nobody had invented a chair before.
I wanted to interrupt you because it's about 6:15 and it's the last class of the semester for my course. And we've got a number of people here who happen to be my students, and I just wanted to wish them the best. You can continue the meeting, but I also wanted to say that before people leave, I don't have any more speakers lined up starting next month. So if you have any suggestions, help your volunteer president try and arrange some interesting speakers. If you know of anybody who would be willing to talk, just reach out to me and I'll be very happy to schedule them for one of our sessions. These have been very valuable for us. And I also, Diane, I wanted to thank you very much. Now I got a question here. It's been queued on the chat. It says, how about protecting a new character for books and TV, etc.? So I don't know if that's a design patent or a trademark or a copyright or all 3.
That's a good question. It depends on how it's used. And since my expertise is in patents, you have to take my thoughts on trademark and copyright with a grain of salt. But I would say the character, it might be good to start with copyright. And then depending on how it's used, if it's used in association with goods, then there might be some trademark potential available for it as well. I'm not familiar with anybody trying to get a design patent for a character because I think it's really more about copyright and trademark. Any other questions?
I guess that covers it. thank you very much for a great talk. And I want to thank everybody here for tuning in. Diane, I've got your PowerPoints. Is it all right if I put those up on our website?
Sure, I sent you the PDF version, so that's probably the best version to put up. It's the exact same document.
Great. So I'll be posting that, and I'll be posting the recording. And I hope to see you all next month. I don't know who the speaker is yet, but we'll try and get somebody.
Doug, could I hit you with one more question or hit her with one more question?
Sure. Why
Uh,
not?
For a patent that had been approved but expired, this happened to be a combustion improvement product. Could it be rejiggered and repatented?
If there's a novel and non-obvious improvement, then that would be protectable. So the question is, how has it been improved? And it is quite common for people to file improvement patents. Most patents that are granted are improvements on something that had come before.
Oh, interesting.
Yeah, there's sort of, you can look at innovation as having 4 different categories. There's the breakthrough innovations where it's completely different than anything anybody has ever done before. And then there's sustaining innovations, which are these small improvements, and that's what most people have. And then there's new market, where you take a product like baking soda and you make it into a refrigerant deodorizer. And then the disruptive, the way I'm using the term disruptive is you take a expensive, complicated device and you come out with a simple and less expensive version. So that would be like the original like iPod minis, and some of it's happened a lot in electronics where at first something is really expensive and complicated, but then there's something less expensive and simpler that then gets good traction because it's available to a greater number of people.
And how do you classify that?
Pardon?
How do you classify that the fourth?
Well, based on an article that I read, they call it, let's see, there's breakthrough, sustain, they call it disruptive.
Oh, disruptive, okay.
Disrupting the market with something that everybody can enjoy, as opposed to just the select few. So, there are other terms that you can use for that, but that's the one that this one article used.
And the second, now in the sustaining, those are the most difficult.
Well, yeah, most typical, right? Sustaining inventions. So those are, once again, if you think about like the iPhones, the original iPhone was a breakthrough. People will argue that, but let's just say it was a breakthrough. Then the next generation iPhone was just an incremental improvement. So that would be sustaining. And then that would, really be the same with each iPhone as it came out, which would be an improvement over the last one. Most of the clients that come to us have an improvement over something that already exists. They may not even know that something else exists, but when we do our prior art search, we find it. But we can still often find that they've come up with something that's a little bit better. So if you've come up with an idea and you think it's already out there, it may or may not be. If there are certain features that are different and better, if a good argument can be made that they're novel and non-obvious, then it's worth looking at patent protection.
Great, thanks so much.
You're welcome.
All right. Well, have a good evening, everybody. Thank you, Diane. That's been great.
Well, thanks for having me. This was fun. So, bye-bye.
Bye-bye.
Thanks again.